where there is a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. Or E, where in exceptional circumstances there is a likelihood that the release of the accused will disturb the public order or undermine the public peace or security. When one is looking at section 60, subsection 4, subsection A, one would have to take into account the following factors. Mindful of the fact that if any of these grounds are established, then the interests of justice do not permit the release of the applicant in this matter. In looking at the ground in section 64A, I would have to take into account the degree of violence towards others implicit in the charge against the accused, any threat of violence which the accused may have made to any person, any resentment the accused is alleged to harbor against any person, any disposition to violence on the part of the accused, as is evident from his or her conduct, any disposition of the accused to commit offences referred to in Schedule 1, as is evident from his or her past conduct. The prevalence of a particular type of offence, any evidence that the accused previously committed an offence referred to in Schedule 1 while released on bail, or any other factor which in the opinion of the court should be taken into account. Now when you look at section 64, subsection B, being where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his trial, the factors that I would have to look at in determining whether that ground has been established are A, the emotional, family, community, or occupational ties of the accused to the place to which he or she is to be tried, the assets held by the accused and where such assets are situated, the means and travel documents held by the accused, which may enable him or her to leave the country, the extent, if any, to which the accused can afford to forfeit the amount of bail which may be set, the question whether the extradition of the accused could readily be effected should he or she flee across the borders of the Republic in an attempt to evade his or her trial, the nature and the gravity of the charge on which the accused is to be tried, G, the strength of the case against the accused, and the incentive that he or she may in consequence have to attempt to evade his or her trial. The nature and the gravity of the punishment which is likely to be imposed should the accused be convicted of the charges against him or her, the binding effect and enforceability of bail conditions which may be imposed and the ease with which such conditions could be breached, or any other factor which in the opinion of the court should be taken into account. I do not deem it necessary at this point in time to go into the factors that need to be established for the invocation of section 64 C, D, and E. If I were to look at the strength of the state case, which falls under the categories that I've mentioned now, on the score also of whether there's a likelihood that the accused, if he or she were released on bail, I would read same with the nature and gravity of the charge on which the accused will be tried. Now, if I have regard to the evidence of Warrant Officer Hilton Botha and the strength or weakness of the state case, I'm working from the point of departure that if the defense had succeeded in showing the state case to be weak, then I hold the view that that is a ground that falls for application as an exceptional circumstance. If, on the other hand, the state, in seeking to establish that its case is so strong that the accused will that the applicant will be a flight risk or cause harm to others, it is for the state to establish that by virtue of the strength of its case before that particular provision can be invoked. Now, having regard to the evidence of Warrant Officer Hilton Botha, let me start there on the strength of the state case, on the issue of a flight risk, on the issue of a propensity to violence. Warrant Officer Hilton Botha indeed made several errors and concessions during cross-examinations, and these are, among others, he didn't bother to ask for the other cell phones that may have been present, nor did he go and check on the cell phone number given by the defense in court. I'm alive to the fact that he testified that he found cell phones, but he is the very one who indicated that there were no calls made from those cell phones. Now, when the defense in court at an early stage of these proceedings indicates that the accused had a cell phone, and this is the number, at no point thereafter does he investigate that further. He does not verify the cell phone information of the deceased. If it was the deceased's cell phone that was on the floor, it is highly important, and of crucial importance rather, to show or not show that there were calls or SMSs that may have been made up to 2 o'clock in the morning. And that would have been an important part of the puzzle. Following procedure is another issue to talk about. He may well have contaminated the crime scene by not wearing protective gear on his shoes. I do think, however, at the time that he entered the premises, much of the investigation would have been concluded. He agreed with the probability of the defense version to the extent that if shots were fired from the entrance of the bathroom, that they would travel in the direction of the toilet. I feel that he could have done more to establish if this applicant had other incidents or a tendency or reported cases wherein violence was involved. He conceded to the court on the court's questioning that his language of choice on certain questions was indeed Afrikaans. Yet, even pursuant to my asking him, he elected to testify in English. He blundered on the exact description of the substance and needles that were on the scene, initially saying that it was testosterone, but very quickly retracting in the face of the aversion that it was testocompasutium. He then agrees there was a second urine sample taken. What happened to the first? Did he write the name testosterone in his pocketbook? He says, no, I had a clipboard. Did you write it in the clipboard? No, there were others who were also taking information. He didn't call Netcare to negate the call by the accused. He wants to oppose bail. In the face of being told there's a memory stick with account numbers, offshore accounts, him being the policeman on the scene did not deem it necessary to seize, with the might of the law behind him, such evidence as is necessary to prove that the accused has got offshore accounts, which was a material factor that I would consider when it comes to his likelihood to be a flight risk. Did he try to establish whether the number given by the defense was the accused's cell phone number? He did, however, I must, to his benefit, add, defend the position that the 3 of the cartridges that were found in the bathroom itself added more weight to the state case that the shots were fired from where the ballistic expert thought it was. I must add that in assessing his evidence and answers, I really feel that it wasn't just through the persistence of the questioning of Advocate Roux that he conceded eventually that on the defense scenario, the trajectory could be the same. He conceded that there was a cartridge outside in the passage, which he omitted in evidence in chief. He also conceded that at this stage, the witness who heard the voices and the arguing could not see where they were coming from and nor indicate that they originated from the applicant's home. What was astounding, of course, was his perception of distance, indicating that the statements of those witnesses and his recollection of the distances of their homes from the applicant's home was initially 600 meters. On questioning by the court and the defense, it then changed to 300 meters and then went even less. I do, however, want to also indicate that his concession that indeed if the deceased's bladder was empty, it would be in line with the defense version that she was in the toilet. Indeed so, there may be other reasons for her bladder having been empty, and I do not think he was the expert to answer that. He was criticized for not testing the version in the affidavit that he wanted to get the firearm in that time that the deceased could have gone to the toilet. Why didn't he go and check it out? He conceded to Advocate Rue that the deceased would have locked herself in the toilet if the applicant had screamed to the intruder, "Get out, Riva, call the police." But it's equally possible, as Advocate Nair pointed out during the address to the court, that the deceased, if she was in the toilet, could equally have asked, "What's going on?" open the toilet door, and nervously come out. I was indeed satisfied on the score of his answer with regard to the contention that the accused, being so vulnerable, would want to seek to protect himself and his girlfriend. Warrant Officer Hilton Botha responded quite confidently, "But why would the applicant charge him to the danger without his prosthesis when there were so many other options available to him?" Now, of course, it is an area of concern that the defense found a spent bullet, and now the warrant officer says he heard about it. But that being the case, even if there was a spent bullet in the toilet bowl, whose fault is it really? But I think what is of primary importance to me is that while there were concessions made by Warrant Officer Botha, Warrant Officer Botha is not the state case. Warrant Officer Botha is a police official that was first on the scene. He is not necessarily the most senior police official who may be tasked with the investigation. It is, of course, desirable, and I will indicate why, that when there is a crime of this magnitude, in terms of the public interest, in terms of who the applicant is or the accused is, it is of vital importance that the South African Police Service, at the very outset, also soon as they learn about the profile of the matter, allocate a very senior and experienced detective to take control of the crime scene, with a view to testifying in court as a matter of course if bail is opposed. Now, Warrant Officer Hilton Botha conceded that there were aspects of the defense version with which he agreed, and that were consistent with the defense's version of the applicant or the accused being in the passage, insofar as the trajectory of the shots. But Warrant Officer Botha's concessions by no way mean that he agreed with the defense version. A version was put to him. He also had the state version, that there were 3 cartridges in the bathroom, and ballistics indicated that the shots were fired from 1.5 meters away. Equally, he on more than one occasion repeated that he considered it improbable. He even went so far as to repeat, as I've said, that there were 3 cartridges in the bathroom. I want to highlight, it can never be said that Warrant Officer Hilton Botha is the state case. It's his evidence that may have been, to an extent, tarnished by cross-examination, not the state case. He is not the state case. The state case comprises of experts who will put together pieces of circumstantial evidence, I would imagine. I cannot agree with the contention detention. That concessions and the credibility of a detective who is on the level of a warrant officer and who on the main agreed with the assertions made by the defense on their version necessarily means that the state case is not strong. We are dealing with circumstantial evidence. What would one expect? There are no other witnesses. The only person who knows what happened there is the accused. Therefore, it is as a matter of course that when you are dealing with circumstantial evidence, pieces of the puzzle need to be put together. And those pieces of the puzzle may not yet all be before me. And of course, the state obviously, in the normal sequence of events, would by the time the state is ready or trial ready, have more pieces of the puzzle. And when that happens, and assuming the matter reaches the stage where evidence is led in the trial itself, and at the close of the state case, for example, if all the pieces of the puzzle leave the court with an inference, as the only reasonable inference to the exclusion of all others, that it was the deceased who knew it was the applicant, who knew that it was the deceased in the toilet, fired from the distance as indicated by the state, then of course, the accused may have a case to answer. In considering the state case and the strength of the state case, I'm also mindful of the decision of S versus Brenkies, 2003, 2 SACR, page 575, Supreme Court of Appeal, handed down by the Honorable Acting Justice of Appeal Shongwe, where at page 578 he goes on to indicate, and this is an application for bail pending appeal, by the way, and I quote, whether the sum of the circumstantial evidence is sufficient to establish the appellant's complicity in the planning or participation in a robbery must be left to the court hearing the appeal, for the purpose of this appeal is not necessarily to go beyond simply stating the evidence. Likewise, I consider the outset of the bail application, where by the very nature of things, the investigation is at a very early stage. This court is left with no option but to place weight on what I have before me. It is, as I've said, practically impossible within a matter of a week for the state to have all the pieces of the puzzle where the applicant is the only person who can tell what happened. And as I sit here, I'm indeed handicapped to the extent that as a court, I have no option but to perhaps look into the future and almost guess the prospects of success of the state case during the trial. Having said that, I will venture to say, and I appreciate that I am not the trial court, inasmuch as the defense has found concessions in the evidence of the investigating officer to their advantage, the improbabilities, as highlighted by the investigating officer, but more underlined by the senior counsel representing the state, there are some aspects of the version of the accused that are quite pronounced. I have difficulty in appreciating why the accused did not ascertain the whereabouts of his girlfriend when he got off the bed. I have difficulty also in coming to terms with the fact that the accused did not seek to verify who exactly was in the toilet when he could have asked. I also have difficulty in appreciating why the deceased would not have screamed back from the toilet. I have difficulty also with understanding why the deceased and the accused would not, of like mind, in those circumstances, escape through the bedroom door, then venture into the toilet. I have a problem also as to why the accused would further venture into danger, knowing full well that the intruder was in the toilet, leaving himself open to be attacked even before he shot, because he heard the noise, left that area, went to fetch the firearm, returned, and to my mind, what if the intruder came out and was waiting for him, and upon sight of him shot him? I have difficulty in appreciating why the accused would not seek to ascertain who exactly was in the toilet. I have some difficulty with the defense version at this early stage for the part of that I play as the presiding officer in the bail application, that the accused chose to sleep